wanted all of your issues resolved before then, and that way, if we needed to proceed, there wouldn't be any outstanding issues in terms of your ability to prepare.
He's protect the state. Well, he's just doing what he has to do procedurally, but this so that we don't run into any issues involving speedy trial and the case is summarily dismissed because of a speedy trial violation or something that could win on an appeal regarding a speedy trial issue.
Okay, well, I wasn't aware of this.
Is it in virtual file or?
It hasn't been put into the virtual file, Your Honor. It is the individual who was added to the official notice of discovery is the police report, so he has not noticed that he's read the police report.
Who's the individual?
I'm not on notice for the report. I'm on notice for the discovery.
Well, no, what they're saying, if they give you a police report, and in that police report, there's a list of witnesses and references to what that person may testify to, that they have, in fact, you are on notice as to the existence of that witness potentially. I haven't read anything. I don't know.
Okay, well,
do you have a report?
I have this discovery, and the report is. I did read it. Now, was the report amended or just the discovery amended?
The discovery was amended to include the witness that apparently was in the police report. And so, do you have the name of that person or not?
If I looked at the report, I can tell you.
Tell him.
I'm guessing it might be Weiss or Weich. If that's the case, then I'll have to go ahead and do a depth one. Actually, I'm going to also I'll be filing the suppression here because they have the citation, but what there is nothing alluding to is the actual rising cause of action.
He is correct. It was Deputy Weich.
Okay, so those are three potential witnesses.
Okay, that's fine. Okay. But there is nothing that's defining the crime that caused the interaction. So
there doesn't have to be a crime to cause the interaction.
Okay.
In other words, and again, I don't know what's in the police report, Mr. Goss. I don't get those documents. It's not my function to review that information beforehand. So you know, and the state knows more about what allegedly happened than I do. But I don't have to know that. That's not my job to read all the police reports and do all that.
Let me say this right here is a general issue. The judge rules on matters of law and the discretion on what they bring into evidence based upon rules of law. Facts are determined by a jury or a trier of fact. If the judge is the only person trying that issue, then the facts are then at that point taken into consideration. So I just wanted to make sure I said and spoke to that. And I did mention the issue of potential suppression hearing, which I know I had brought up before. Let me say this also: the entirety not the entirety. Sometimes people think that traffic infractions because they're not crimes, don't allow a police officer to engage you. That's patently untrue. So don't move forward thinking that you can just say because it's not a crime, as I did in my ignorance here, saying what's the crime. I should have just said what was the cause, the reasonable suspicion or the probable cause of them stopping me at the time they made the stop.
I rely on what's produced at trial, and that's the only thing I consider in these cases. But go back to the issue of failure to provide adequate discovery. It looks like they've given you every written document that they have. They've given you a list of all the witnesses that they have. And so outside of something else that I'm not sure you're requesting, I'm not sure, there doesn't seem to be anything else legally they're required to give you. So what else do you think you should get that you haven't got?
Okay. I'm unclear, so I'm going to ask the court for clarity.
Sure.
Is it the court's position or the law that a police officer can engage somebody simply for going about doing something that otherwise is not? In other words,
it's not a crime.
It's not a crime.
Yes.
He can engage.
Absolutely.
And then I guess the court
absolutely
will provide.
Let me give you an example.
Okay.
I'm on a highway. The speed limit's 55 miles per hour. I'm going 75 miles per hour. Officer stops me for speeding. It's not a criminal offense, but it is a violation of Florida law, and is a civil infraction. And a law enforcement officer not only has an obligation, but has the legal right stop someone, detain them for purposes of issuing a civil citation for violation of a civil law or civil infraction. And so it doesn't have to be criminal in order for a law enforcement officer to stop you, detain you, limited detainment for purposes of issuing you a citation for a civil traffic violation.
Okay.
That's my belief as to the law.
And he also spoke to the fact of limited. He said limited detainment for the purpose of issuing a citation. And again, he's correct in that. So let's just make sure that we don't continue with a lot more of the things that have gotten a lot of people in the trouble that they may not have needed to be in, when you could probably find a number of other reasons or a number of other flaws in the case that the state may have against you based upon the information that was relayed from the police officer.
Okay, now.
And again, you may not agree with it, but
Okay, now I'm gonna look for the case law because I'm gonna say specifically if.
let's go back to the discovery because
Okay, well, okay, that's one of the things I asked for in discovery is what specific event occurred that would have had him engage me at all?
Okay, so do you have something along those lines in the report